Welcome to Chapter 7, National Origin Discrimination. As you'll read through and learn in this chapter, the purpose of this chapter is to identify different forms of discrimination on the basis of national origin. This type of discrimination may not be as familiar to you because it doesn't really get the kind of attention, like the kind of press that other areas of discrimination might have gotten in the media, for example, like race discrimination, gender discrimination. And so sometimes I find that students are a little confused about what's actually meant by national origin. For instance, everyone has an ancestry, a national origin, a citizenship. So what's the difference? Well, in this chapter, you'll learn a little bit more about how the EEOC has issued guidelines in these areas, and you'll kind of see the connection, how it plays out in an employment context, and the relevance of Immigration Reform and Control Act and how it plays into national origin discrimination. Okay, so let's go over the learning objectives we have for this chapter. After going over this chapter, as a student, you should be able to describe the impact and implications of changing demographics of the American workforce, define the prima facie case for national origin discrimination under Title VII, explain the legal status surrounding English-only policies in the workplace, describe what's in a claim for harassment based on national origin and discuss how it might be different from one based on other protected classes, identify the difference between citizenship and national origin, and explain the extent of coverage of the Immigration Reform and Control Act. So in your textbook, if you look at Exhibit 7.1, you'll see the legal basis for this protection against national origin discrimination. This legal statutory basis comes from sections of Title VII, Civil Rights Act of 1964, and then also of the Immigration Reform and Control Act of 1986. And further clarification is also available from the EEOC's enforcement guidance on national origin discrimination. So when I was a kid and in social studies classes here in the United States, I always heard the expression melting pot, that the United States is a melting pot. I think nowadays sometimes we hear other ways of kind of characterizing the United States as maybe a stew or a salad bowl of different cultures. And so I kind of want you to think about what your perspective and your philosophy is and how you would kind of characterize, our overall big picture of the United States and where people come from and all the different cultures that exist here in the United States. National origin was always included in Title VII's list of protected classes, and the importance of it in this employment law context is to ensure that employers don't make employment decisions based on someone's country of origin. There is a long history of bias in the United States about immigration, and we're not going to get into all the history of everything, all that. But there are distinct issues kind of that are separate from race that are about national origin and immigration, and some involve, language barriers and things like that. So that's what I want you to kind of keep in mind, are what your experience is and what you already know as you add more knowledge during this chapter to this category. So in the United States, we always see changes happening in the workforce. In the past decade, or I guess a little more than a decade, some of these statistics are almost a decade old themselves, from your book, there's been large increases in the number of immigrant workers in the United States, particularly from, as you can see here with these numbers, from Asian and Latin American countries. And in 2017 alone, the United States was home to 44.4 million immigrants in the United States, and those numbers are always changing with time. Looking at some of the data and statistics that are gathered, these statistics show that foreign-born men are more likely to participate in the labor force than women, and there's a substantial wage gap that is still being measured when it comes to education levels, not so much at the higher degree levels, but there's, some differences, and especially in this past century, EEOC complaint volume has increased. And so it's important to remember that when we're talking about national origin discrimination, on its face, sometimes it seems like it would be relatively simple to determine, but sometimes there's surprising underlying, complex issues that come into play. But it's important to recognize, some of the things that are different when it comes to the realities of national origin discrimination. For example, citizenship status and national origin are not necessarily synonymous. And no matter the national origin of like a restaurant, for example, as an employer, it's likely still going to be required to abide by Title VII non-discrimination principles when they're hiring servers. The EEOC considers English-only rules applied at all times presumptively discriminatory, although courts have not always agreed. So there's definitely some different perspectives on where and when English-only rules might or might not be appropriate. So the discrimination protection under Title VII for national origin is going to be very similar to other protected classes that are covered under Title VII. So when it regards employment decisions, classification of workers, anything that affects a worker's privileges, benefits, opportunities for advancement in employment, those kind of protections are going to look similar in this category as they do in other categories. And when we're trying to define what national origin is really talking about, think of it similarly to someone's ethnicity. They can have claims that are based on disparate treatment, intentional discrimination, or disparate impact, that unintentional discrimination. And particular issue, again, that kind of comes up in this context would be an English-only rule that might impact different groups differently, even though it seems neutral on its face. So how does an employee who is building a case who is alleging discrimination, what does that prima facie case look like? So first, they have to show they're a member of that protected class. They were qualified for the position they applied for or in which they were employed. The employer made an employment decision against this employee or this applicant if it's earlier on the timeline, and that position was filled by someone who is not a member of this protected class. So we're going to go through each of those elements separately. So who's a member of the protected class when it comes to national origin? Well, national origin is going to include the employee's place of birth, ethnic characteristics, or origins. Under the EEOC guidelines, it covers discrimination because an individual or their ancestors or from a certain place or have the physical, cultural, or linguistic characteristics of a particular national origin group. And so there's a couple things I have here that I want you to note. National origin discrimination can include discrimination by members of the same national origin group against each other. So they don't have to be they can also be from that same protected class. They don't have to be from a different national origin group. And the other thing I want you to kind of note is that protection against discrimination is based on the country of origin and not necessarily the country of citizenship. Because citizenship is not a protected characteristic. That's not one of those protected classes under Title VII. And so these are also situations that can serve as a base for national origin basis of a discrimination. If someone is identified with or connected to a person of a specific national origin, so for example, if someone suffers discrimination because they are married to someone of a certain ethnic heritage, or if they're a member of a group that is connected to or identified with a particular ethnic heritage or national group, if they participate in a school or religious organization that's affiliated with a particular national origin group, maybe they have a surname that is generally associated with this particular national origin group, and they are experiencing discrimination, or they are perceived by an employer to be a member of a particular national origin group, whether or not the individual is in fact of that origin. So mistake is not a defense against discriminating against someone because someone assumed they were part of this national origin group. And so just to make sure we enforce this as always, if someone is the claimant, they're claiming they've been discriminated against based on national origin, they always have to show that minimum basis that they meet the job's requirements. The claimant has to show that he or she, they met the job's requirements, and no employer accommodation is required for a national origin claim of discrimination. There are very narrow exceptions that would include a BFOQ, remember, bona fide occupational qualification. But again, the EEOC is going to really kind of limit that, narrowly construe that. And that narrow exception is definitely not going to include someone who is just like a preference. So, for example, if an ethnic restaurant wanted to only have servers that reflected the ethnicity of that restaurant, that's not a good enough reason to discriminate against someone who is not of that national origin when they can do the job just as well as someone else from the other ethnicity. And then again, just to remind you again, citizenship is not the same as national origin, and citizenship is not going to be a protected category. Okay, so let's shift gears into talking about English fluency and language restrictions in the workplace. I have a few different slides on this because this is definitely a topic that kind of comes up more in this category. Fluency requirements, accent issues, whether someone is understood clearly, may go towards qualifications for certain job positions. And English-only policies are becoming relevant in the workplace, but the question is, when are they appropriate or not appropriate? It's going to be kind of a case-by-case thing. The EEOC has shown preference for, only having a business necessity of English only, but courts are not required necessarily to follow the EEOC's preference for policies. And so they're going to, again, look at the details of the situation. But as of right now, we don't have any Supreme Court rulings, which would be something that would change, the lay of the land across the whole country. So it's more about what the lower courts have decided in different areas, and they have some variability into their rulings. And so what we see coming out of these cases is that some kind of blanket fluency requirement for like all jobs, no matter what the job is, if it doesn't have a legit business justification, like what's that business necessity that is based on, these fluency requirements or these English only requirements that justify it. And then making that distinction between work time versus break time. If there are employees at a workplace that speak their first language is the same as each other, who is an employer to say you can't speak your native language when you're in the break room or out to lunch or something like that? That seems like to be an extreme stretch and is not usually going to be justified in the court system. So what does business necessity look like when we're talking about English only type policies? Communication with customers, coworkers, or supervisors who only speak English. If it's an emergency or another situation in which a worker needs to be able to communicate in a common language for safety reasons, for team and cooperative work assignments, an English only rule might be needed so that we can promote efficiency, for example, or to enable a supervisor who only speaks English to be able to supervise and monitor the performance of that employee whose duties require communication with them. So I've mentioned this before, but it's important to note that, courts give deference to these EEOC guidance, but they're not necessarily required to follow it. They have allowed restrictions that were based on sound business interests in the past, and that's kind of what we can expect to see from courts, I think, going forward, short of a Supreme Court decision that kind of sets the standard for the whole country. The categories where the courts have kind of upheld English fluency or English only rules, of course, when it's connected to workplace safety, about efficiency with someone who's a supervisor and only speaks English, customer relationships, coworker relationships, and teamwork, within that business justification is what's really important. And, but we have a little bit of variance and differences throughout the country. And so I want you to kind of, if you're thinking about these different situations and where it's more or less important to have these kind of policies, where they're appropriate or not appropriate, I want you to think about how multilingualism, like people who are bilingual or multilingual, how that can contribute positively to organizations today in a global economy. There are benefits to that, having this extra skill in a workforce for people who can communicate, in this global economy could be really helpful, but it also can present unique challenges to employers. If there's problems with poor communication, especially if it's someone who doesn't have a second language and someone prefers to speak in their native tongue and that's not English, These communications can sometimes cause confusion, or they could even, be a safety hazard, or sometimes it, is more appropriate for one job and not for another job. But severe English only restrictions can create frustration and resentment among employees where English is not their second language. So it's important to have, realistic and reasonable job qualifications to decrease the risk of litigation, and not have just arbitrarily imposed language restrictions. It's important that it is, narrowly tailored and makes sense for that business necessity. And then, of course, when it comes to like a rule about fluency, fluency is different depending on what the job. So a blanket fluency requirement doesn't necessarily make the same amount of sense if we're talking about the customer service department dealing with, outside customers who typically only are going to speak English, to warehouse workers communicating with each other, and they can communicate in maybe a native tongue that they share together. So it's, again, it depends on the circumstances of the situation, what is appropriate. Okay, so the third element of the prima facie case for national origin discrimination is that the employee has suffered an adverse employment action by the employer's employment decision. So this could be like anything that's any action or omission of an action. It takes away or prevents benefit, opportunity, or privilege of employment from that employee. Again, disparate treatment, those intentional policies, or disparate impact of something that seems neutral on its face but has a discriminatory effect, both could qualify under this adverse employment action. And the prima facie case, building that prima facie case, will trigger the employer's requirement to defend based on a legit non-discriminatory reason, or a BFOQ, bona fide occupational qualification. And then, of course, the fourth element requires the employee shows their position was filled by someone who's not a member of her protected or his protected class, or under other circumstances that those who are not members of the protected class are treated differently than they were. So in addition to providing protection against traditional types of discrimination, Title VII also protects employees against harassment on the basis of national origin. But remember that not all harassment is going to be prohibited under Title VII. Similar to claims of sexual harassment, claims of national origin harassment are only actionable if the harassment was so severe or pervasive that the employee reasonably finds the workplace to be hostile or abusive. Common concerns might include things like ethnic slurs, workplace graffiti, or other actions or offenses that are based on traits like an employee's birthplace, their culture, their accent, or their skin color. And these kind of claims have sharply increased since the late 1990s. And they're showing that these are just, so intolerable that no reasonable person would be able to tolerate this kind of harassment in the environment. And company involvement or tolerating this behavior, they knew this was going on, or they should have known because it was happening in front of other people. The key concern, again, is how reasonable is it for someone to tolerate like a little bit of teasing versus conduct that is so offensive or hostile that no reasonable person could tolerate working in that environment. So here are a couple examples of national origin based harassment. These are EEOC guidance examples of what would violate Title VII and conduct that would not be considered a hostile work environment based on the standards in Title VII. And as you can see in these examples, in the first example, we have someone who has regular, persistent behavior against them in their work environment that is harassing them, versus the second example where someone is experiencing occasional harassment or teasing based on their national origin. And of course, in both situations, it's unprofessional and disgraceful that this would even be going on in a workplace. But hopefully you can kind of see the difference between something that is going to be the hostile work environment that violates Title VII versus just inappropriate conduct, but it doesn't rise to the level where it's intolerable by a reasonable person. So for federal agencies or contractors of the federal government that do business with the government, they have an affirmative duty to prevent discrimination based on religion or national origin. There are 8 requirements to this guidance, including internal communication, workforce analysis, enhanced recruitment efforts, And provisions specifically include the following ethnic groups: Eastern, Middle, and Southern European ancestry groups. And this also is including Jews, Catholics, Greeks, and Slavic groups. And excluded because they are covered elsewhere would be groups of Blacks, Spanish, surnamed Americans, Asians, and Native Americans. They're specifically included from these guidelines specific coverage because their protection exists elsewhere in the Office of Federal Contract Compliance rules. And due specifically to a rise in anti-Semitism across the United States, the EEOC also formally condemns any anti-Semitic behaviors against Jewish people. So in the aftermath of the terrorist attacks on September 11th, 2001, and following other terrorist attacks made since that time by extremist groups like the Islamic State, hate crimes against individuals of Middle Eastern descent have increased dramatically. And so workplace discrimination complaints brought by Muslims and others of Middle Eastern descent have also risen sharply in the last 20 some years. An example of, these workplace discrimination in your book is the Ford Motor Company case. But there's some key discrimination issues that have come out of these cases. And there's a little bit of that overlap between national origin discrimination cases and religious discrimination cases. That's why these couple of slides kind of bring these two together, even though we'll discuss religious discrimination separately later on in this book. But some key issues were different treatment because of someone's religious attire. So, for example, hiring discrimination for an applicant that wears a hijab, ethnic harassment, and unfairly saying that it relates to security concerns when it doesn't legitimately necessarily connect to those specific security concerns, or experiencing discrimination because of someone who comes from a Middle Eastern background is exposed to more stringent security checks or other pre-employment requirements that are not being required of other applicants similarly situated. Employers are not allowed to require individuals of one ethnic background to undergo more significant security checks or any of these other kind of pre-employment requirements unless they're requiring that of all their applicants for that position. And they're making everyone applying for that position do the exact same thing. In the post-September 11th era, employees actually have this unique opportunity to raise the awareness and sensitivity to cultural diversity in the workplace. There may be some situations where, a security program, national security of the United States, or a security program is that's an important element. But again, situations where this is used as a justification are going to be extremely rare. Discrimination of people from Latin origin, Latinos, Latinx, those might be terms you've heard before, especially recently in the news, have really increased in all these different categories that we kind of talk about. This is a particular category where we've seen a lot of increase in the last decade or so, and a rapid increase in hate crime targeting and issues involving immigration and the southern border of the United States with Mexico. And there's a lot of widespread perception among this workforce segment of pressure to repress heritage or to conform. And when this kind of discrimination is happening, it naturally spills over into the workforce when you see this kind of rhetoric happening, in the media or on social media or things like that. And then, of course, one thing that I like about this textbook that it points out is some of the practical approaches and solutions to things. And it says that, it points out that because the Latino population has grown a lot in the United States in the last few decades, that multiple negative impacts can transcend legalities. The effects of discrimination go beyond just this liability in workplace. Workplace discrimination can impact workforce productivity. It can impact the ability to be more productive, or when businesses are not able to tap into the growing market of some of these groups that are growing in the United States, that can have a loss of sales and opportunities. So again, want to differentiate here between citizenship and national origin. So Title VII prohibits discrimination on the basis of national origin. It does not prohibit discrimination on the basis of citizenship. So non-US citizens are often restricted from access to certain kinds of things based on statute or ineligibility for certain jobs. And so that is something that is not protected by Title VII. That is something that could be a requirement of a job. But where Title VII kind of comes into play is when citizenship discrimination is being used to have the effect of national origin discrimination, or it's kind of a pretext for national origin discrimination. Legal immigrants are often restricted from access to certain government or other positions, by statute. So we're looking for a difference between legit citizenship requirements for employees as opposed to a pretext for national origin discrimination. And then, of course, a statutory foundation when it comes to Immigration Reform and Control Act, it is unlawful to knowingly hire, recruit, or refer aliens not authorized to work in the United States. So that is people who've come over illegally or don't have the paperwork that authorizes them to work in the United States. So it's important to know that the employer is the one who's breaking the law. It's illegal for an employer to knowingly hire someone who is not legally authorized for employment. And under the Constitution, a legal alien, so someone who is an immigrant with a legal status, is guaranteed certain rights pursuant to the Constitution, but there are still certain things that the law confirms as benefits only to those who are actual U.S. citizens and not just legal residents and non-U.S. citizens. And so it's important to note that the Immigration Reform and Control Act, in contrast to Title VII, does prohibit employers in certain circumstances from discriminating against employees on the basis of their citizenship or intended citizenship. It makes it illegal for employers to knowingly hire those not legally authorized for employment. It also allows discrimination in favor of U.S. citizens against legal aliens. And while legal aliens are guaranteed various rights, it's important to distinguish the difference. And it also has coverage for smaller employees. So an employer that's not subject to Title VII statutes because they have less than 15 employees may still be covered under anti-discrimination provisions. If they have 4 to 14 employees, they're prohibited from discriminating on the basis of national origin. And employers with 4 or more employees may not discriminate on the basis of citizenship. Okay, so we've talked about U.S. citizens, we've talked about legal aliens that have paperwork that are not U.S. citizens but legal right to work in the United States. And so another category that's important to cover in this chapter is the category of undocumented workers. So people who have immigrated without the appropriate paperwork. The numbers on how many undocumented immigrants actually are living in the United States are not fully known. Approximately, the guess is, here or there, but the number is kind of hard to really fully account for. Some numbers that we have from your textbook: in 2007, there was approximately 12 million undocumented immigrants living in the United States, and 8.4 million undocumented immigrants made up around 5% of the nation's workforce. In 2017, about 10 years later, the number had dropped to 10.5 million undocumented immigrants, and of those, 7.6 million were in the American workforce, which accounted for 4.6% of the workforce. So that's why I have here that, they likely comprise about 4 to 5% of the workforce. When an employer is collecting paperwork for a newly hired employee, they have forms. There's a form called an I-9 where the employer is required to verify any new hired employee, to examine their documents and identify that that individual has the authority to work in the United States as they produce the papers that they have for this I-9 form. And there's this thing called the no match issue. And so employers were given 90 days to reconcile no match letters. If they had employees that were suspected of using false social security numbers that did not match the hired employee. And so over the years, there have been different versions of no match letters issued by the Social Security. Letters are written when it doesn't appear that the number in the Social Security Administration matches the employee that is claiming to have that number. And, you know, those guidelines will continue to change. So how would you, as an employer or leader in an employee situation, like how do you handle that? Well, the Department of Justice gives advice to employers who have received these no match letters. So their advice is, you know, to check information, compare it with personnel records to eliminate any kind of administrative error, like there was a typo, you know, not an automatic termination. Inform the affected employee, seek numbers confirmation. Maybe they have a correction that they can make. Advise the employees to correct any discrepancies with the Social Security Administration. Uniform rules for all employees, reasonable time to correct data, and then submit those corrections to the Social Security Administration. Investigations with random I-9 audits and compliance could happen as inspections by the Immigration and Customs Enforcement branch of the government, known as ICE. So an important thing to note here is that a worker's undocumented status doesn't justify workplace discrimination. Undocumented workers are particularly vulnerable to threats against them to report them to ICE or another agency. And, you know, so a worker's undocumented status absolutely could serve as a legit reason for an adverse employment action. For example, once that is discovered if it wasn't previously known. But an employer who knowingly employs an undocumented worker cannot assert this defense in a discrimination claim. So they couldn't knowingly employ someone who's undocumented and then say, oh, well, that's why this negative action is justified because they were undocumented. And so I want you to kind of think about this extension of rights, you know, to undocumented workers and think about the consequences if the rights weren't recognized or if they are recognized, because this is definitely an area of, you know, discussion and some controversy with how and where and when these things should apply to undocumented. And so it's important to kind of consider these issues because they are issues that come up and they're not completely all the way fleshed out. And then also, I want to note for you guys to understand that the Fair Labor Standards Act, you know, the Department of Labor statutes, they protect undocumented workers from abuses not involving future pay. So we do spend a lot of time focusing on Title VII because it is probably the most popular basis for someone making a claim of discrimination based on national origin, but it's not the only statutory basis for someone to make that claim. There could also be a claim under Section 1981. So even though Section 1981 originally was designed to prohibit racial discrimination, the law also applied to identifiable classes of persons who are subjected to intentional discrimination solely based because of their ancestry or ethnic characteristics. So it's still a very narrow interpretation. It's not going to be extended to gender claims or Amish employees. It's come out through the courts, so it's not going to be broadened to that point. But Section 1981 is broadened from not only just race claims, but also to national origin claims. So management tips. You know, there may be a specific national origin that is a bona fide occupational qualification. It's a BFOQ. You still need to make sure that only individuals of that origin could do the specific job, since courts really do have a high standard for BFOQs in this area. So again, using the example of a restaurant that is serving food specifically of a particular ethnic type, there might be certain positions that could be justified that's a BFOQ, but someone who's working as wait staff or as a server, it would be really hard to make that stretch that this is a requirement for this job. And so another tip, an employee can have a claim for national origin discrimination if they are simply perceived to be of a certain origin, even if that individual is not in fact of that origin. So if they are experiencing harassment or discrimination because someone is making a judgment against them because of, again, their last name or who they're married to, or maybe the way they look, they're assuming things about their ethnic origin, it could still be a claim for national origin discrimination, even if it was a mistake that they're not actually of that national origin. And then looking at English fluency, there can be requirements that are justified for English fluency, but someone is not allowed to discriminate because of an accent unless that accent makes it impossible to understand that individual. So be very cautious in evaluating that requirement on a job, because there are typically going to be other positions that don't necessarily require someone to really speak fluent English or not have an accent, that they could still do their job completely fine. And, preference and comfort or discomfort are not going to be able to justify the source of a BFOQ. If someone is working as a federal contractor, it's important to remember you have additional responsibilities to engage in outreach and positive recruitment activities under the guidelines on discrimination because of religion or national origin. And while someone's not prohibited from discriminating on the basis of citizenship under Title VII, you are prohibited from discriminating on the basis under IRCA. So before instituting a policy, make sure that you are considering both statutes. And then looking in this post 9/11 era, there's specific concerns regarding Middle Eastern employees, the topic of ethnic diversity and any workplace diversity kind of training or discussions. It's important to make sure that those that people remain sensitive and flexible and intervene properly if there's incidents of harassment. In today's world, there is a very increasingly diverse workforce. Different situations that happen in society, in the public, and social media, online, conflict and climate crisis forces people to make decisions. They might migrate north. It's very likely that we would have an increase in Latino, Latinx, and other migrants joining the American workforce. There's changing political climate, and so it's important to make sure that you, as a future manager, is able to respond to whatever those changing needs look like in your workforce, and who those workers are and where they're coming from and what kind of things you need to be prepared to handle. So in summary, the big area of legal basis for national origin discrimination protection is going to still be Title VII. It makes it unlawful for employment practice to limit, segregate, classify employees in any way that could deprive them of employment opportunities based on their national origin. And those elements of a prima facie case are 4 elements. Individuals a member of a protected class. They are qualified for that position. Remember, qualification is always important. Someone can't just be a member of a protected class and not be qualified. An employer made an employment decision against the individual. So some kind of negative employment action, or if they're not employed yet, it was in the recruitment process. They were overlooked. They're not offered a job. The position was filled by someone else, not in that protected class, or they lost out on promotion, et cetera, et cetera. We're talking about all along the timeline. So sometimes the wording of these different elements are going to be different, but we're still looking for all 4 of those elements in a prima facie case. An employer can defend against a discrimination claim if they can show national origin was either a BFOQ, was a bona fide occupational qualification, but in general, remember, that's a really narrow thing. So it's kind of hard to do because it's not super wide open. It's very narrow exceptions. It's a legit BFOQ. One of these exceptions to the difficulty is the requirement of English fluency, clarity of communication, if it's a substantial portion of the individual's job or it's related to safety or something like that. No accommodation of a worker's national origin is required, as it would be in situations involving disability or religion. So we talked about how there's sometimes a little bit of an overlap when it comes to national origin and religion, in the example of, hijab being part of a dress code situation, but it's not typically going to include any kind of accommodation just based on national origin.